Um, so, preventing and acting upon discrimination in AI systems. You've had a lot of conversation yesterday about where we are in developing systems to regulate artificial intelligence, and this is an extremely important topic. In my discussion with you, I'm going to take a step back into the present rather than looking at the future landscape for regulation, although I shall have a little bit to say about that. The reason that I'm looking at the present is because of the discriminatory impact of many artificial intelligence systems. And in my talk, we're going to look at how this can happen, how it should be addressed, and what the participants in this conference need to be thinking about after today when they mull over what they've learned from this project. So let me tell you a little bit about the AI law consultancy. I am a barrister based in London, but for over 40 years, I've been working in the field of equality law, and I continue to do that, although I'm much more focused now on advisory work than taking cases into court, although shortly I will tell you about one case that we did last year. Together with a colleague in my office, Dee Masters, in 2018, we set up the AI law consultancy because we were increasingly aware about the extent to which AI systems were having discriminatory impacts. But we, both of us, had worked and continue to work in the field of equality law, and so had a particular interest in thinking through how these new systems impacted on individuals. And since then, we have been privileged to be engaged with a very broad range of different organizations and people in discussing these topics: NGOs, human rights organizations, unions, business, and governments. We've lectured at the ERA a couple of years ago. We've written public opinions about these issues for the Legal Education Trust, two major opinions in relation to that. And then we were privileged to be asked by Equinet, the European network of equality bodies, to write a report on regulating for an equal AI, looking at what equality bodies themselves could do, looking at how governments should approach these issues, considering the question of equality and non-discrimination. That report had an introduction from the European Commissioner, Lally, so we are very privileged to have been involved in that, and it was cited in the Commission's white paper in advance of the consultation about the AI Act. We've been asked by the Council of Europe to prepare a training program, which we've delivered for European regulators, and some people perhaps know about this. It's been delivered first in the United Kingdom. It's been rolled out in France, and I believe it's being rolled out in Spain. We've written a report on managing people through technology, the legal implications for the United Kingdom Trades Union Council, and ETUC have certainly looked at this and picked up some of the points that we've made. We have just finished working with the UN Special Rapporteur on Disability, who published it was officially published in December, but presented to the Human Rights Committee last month, a thematic report on artificial intelligence and disability. And we've just finished working with the United Kingdom government, who, after Brexit, have been looking at the GDPR and thinking about how the GDPR should work with equality law. And we'll talk a bit more about that later on in the course of this session. So we've had quite a broad overview and continue to be engaged in these technical issues, legal issues, and case law concerned with the interrelationship of the development of artificial intelligence systems and equality. Now, I'm going to cover a little bit of ground quite quickly that you will already have been looking at yesterday, but only in a way to set up some of the things that I want to say. So the next few slides I shall take fairly quickly, but just to remind you of why this is important. So artificial intelligence, what is it? Well, you heard debates about the definition that could be given in relation to that. When we do these talks, we always like to start with a lovely comment from Professor Frederick Borgesius in the report that he did for the Council of Europe 2 or 3 years ago now, saying, in short, artificial intelligence is the science of making machines smart. That's true, but machines that discriminate, or systems that discriminate, are not smart. And the key here is to work out how machines can be made smart, have artificial intelligence, but can avoid discriminating. And we'll talk about that as I go on. The AI Act, in its draft form, has a rather longer definition, and we'll need to just focus on this because I need to unpick it with you in order to see how discrimination can occur. It says, artificial intelligence systems receive machine and/or human-based data and inputs. So concentrate on those words, data, inputs. Okay, we'll need to come back to that. Then it infers how to achieve a given set of human-defined objectives using learning, reasoning, or modeling, and it generates outputs in the form of content, predictions, recommendations, or decisions, which influence the environment it interacts with. So if you think about it, it's a process. It starts with data inputs. It then looks at that data to model it, and it generates an output which has effects. And it's those effects which need to be thought through. So again, the key concepts that we need to think through and have very much in mind when we see how discrimination can occur. Quickly through them: algorithms, the instructions to the machine; machine learning, the technique that allows algorithms to extract correlations; automatic decision-making, decisions or conclusions often reached without any direct human involvement; profiling, the processing of personal data consisting of the use of personal data to evaluate certain personal aspects relating to natural people and to make predictions concerning that natural person's performance at work, economic situation, health, personal preferences, interests, reliability behavior, location, or movements. And then training data set. This is the data set used for training an AI system through fitting the data to learnable parameters. And this training data set point is particularly important. It goes back to what we were saying about the definition. You have training data that the system then works on to make predictions, and then you put further data in, and the predictions are applied to the data that goes in, and then the system produces an output which has an impact. Now, we also think need to think a little bit about the life cycle of an AI system, because as we come to discuss how discrimination can occur and how it can be taken out, this life cycle is highly typical. And it is an iterative process. In almost every case that we have been involved in, something like this life cycle is involved. First of all, if we take it at the top, business usually, but it could be government, has a use case development. They identify a problem and seek to make improvements, and these are explored and defined, and then the use of an artificial intelligence system is proposed. And then we have, going round the circle in a clockwise fashion, a design phase. The business case is turned into a design requirement for engineers. And then the training and test data procurement, the training set. An initial data set is obtained to train and test the model. You remember yesterday there was some discussion about the fact you can buy data sets for this training. Then the building of the model, the AI application is built, it's often tested, then deployed, and it should be, but isn't always, monitored. And then the circle is likely to go round again. So that's the kind of life cycle of an AI system. Now let's look at the landscape to see what we're talking about when we're discussing the kinds of things that AI is engaged with. First of all, artificial intelligence and ADM systems are now operating everywhere and affecting everyone. I was talking last week at a conference of ECRI and the Council of Europe, and before that, at the launch of the Special Rapporteur's thematic report. And it's perfectly clear that literally across the globe, these systems are already operating. They are universal in their application. They have a significant scope to affect people in a discriminatory way. And you can see that very simply by the fact that if the training set, the way the training set works and the way the system works, essentially, these are stereotyping systems. They take a training data set and make a prediction from that about correlations. And in short, they say that people with the following characteristics or situations with the following characteristics are likely also to have these characteristics. And that is, of course, discriminatory if it's then applied to situations which are not wholly applicable to it. There is so far very little litigation with few significant judgments about the way discrimination works. And I'll explain a bit more about why that should be as we go along. Firstly, there's a huge power imbalance, and we'll come back to that. People don't always observe what is happening to them. They often don't, the impacts can be quite short-placed. Sometimes they're very long-term, and then there has been litigation. But sometimes it's quite short-placed and people just shrug their shoulders and move on, even though those short-placed interventions may be repeated time and time again. An example of that might be that your data profile is online and you get advertising put to you. You don't know necessarily what advertisements for what jobs or what commodities have not been offered to you. You only see the ones that have been, and you may receive other information from different situations. But nonetheless, the system is discriminating in the way that it is profiling you and offering you what it thinks are the things that you ought to see online by way of advertising. And AI and ADM are having a very big impact on Article 8, European Convention of Human Rights, privacy rights, in lots of different ways. So profiling in the way that you walk around, biometric censoring, and such like. And obviously, AI and ADM are closely connected with data protection rights. But here is the point which is increasingly seen as being very significant. The way in which the GDPR works and the way in which equality law works are different. Equality law says that you can do anything you like as long as you don't discriminate. And if you discriminate, then equality law is engaged. In the European Union, those rights will derive from things that we know well about already: the right to equal pay for work of equal value, the prohibitions on discrimination on grounds of sex, gender, age, disability, sexual orientation, religion and belief, and race and ethnicity. The way the data protection rights work are to say that you cannot use data at all except in the limited examples in which it is permitted. So it starts from a general ban with permitted exceptions. And we're beginning to see that there is an increasing problem in melding those two different legislative approaches together. We can talk about that in the questionnaire session later if you wish, but it's a connected problem with the way forward in making sure that these systems operate cleverly together. So let's look at the different sectors in which discrimination from AI systems are working. And take that, first of all, in biometrics, censoring, in employment and recruitment. I'll just give you an example of the employment and recruitment. We had quite a lot of discussion about biometrics yesterday. In employment and recruitment now, if you or your children are just entering the labor market, the most common way now to proceed will be to put your curriculum vitae onto a work board, and you will hope in due course that somebody will make you an invitation to come and be interviewed for a job. What's happening is that AI systems are being used by recruiters to, and the phrase that's used is to scrape the web to look for potential individuals. You don't know whether you're attractive or not and how that system analyzes your online presence to determine whether to offer you a job interview. But it is happening absolutely all the time. All those now coming out of university or entering the job market in their 20s experience this. This is a current problem that is very, very significant. In public services, increasingly, the pressure to make decisions fast and to try and get internal consistency in those decisions is leading to AI systems working in relation to the delivery of social advantages of all kinds and public services when they are to be delivered and when they are to be denied. AI systems are used across all kinds of financial services to determine creditworthiness, to decide at what cost financial services will be offered to you and when they will be denied. And it's been used in consumer decisions, as I discussed just a moment or two ago, and in justice and policing. And we're going to hear a bit more about that in the next session this morning. So pretty much across every single sector, this is happening. And I'm just going to talk a little bit about one or two well-known examples of how this can operate. And one of the ones which I find very interesting is the AMS, Automatic Assistance System, used in Austria, which was started in 2021. And it looked to calculate the future chances of job seekers on the labour market. The little picture you have on your screen are people queuing up as job seekers in a job agency. And the way this system operated, it was on the basis of past information, the training set, to classify individuals into 3 groups to which different resources for further education were allocated. The AMS algorithm used was very controversial and was alleged to be highly discriminatory. It was reviewed by the Austrian Academy of Sciences, analyzing the technical functioning and social impacts, together with the Technical University in Vienna, acting on behalf of the Chamber of Labour. And it worked through the way in which the system operated and determined that, in fact, it was a myth that the AI system was value neutral. It always anchored around various norms and interests in society, and it was presented as being objectively fair, but in practice, it was operating in a discriminatory way. And it's now come under very heavy criticism in Austria. So another one, an earlier and much more simple example of this was Amazon, that used an AI system for recruitment. It based its training set on its existing employees, and then was surprised to discover that the AI recruitment tool seemed to prefer men to women. It worked out quite quickly that the reason for this was that the training set was skewed towards women. And it's to its credit that it changed and took that system away and altered it. Another very well-known and rather scary example is something that we all know a little bit about: posting photographs online on the net. And Google has an artificial intelligence program which will tag those photographs. And in its early iteration, it considered that Black faces, people from the Black and minority ethnic communities, looked like gorillas, and tagged photographs of people with Black features and Black skin color as gorillas. Highly discriminatory and very unpleasant. And again, I must say immediately that Google has changed that system, but it's an example of how discrimination can fit in. We also heard a lot yesterday about what had been happening in Holland, in the Netherlands, with the system risk algorithm used by government to determine whether or not people were defrauding the state system of social advantages. And this was using data from the local authority, the municipality, from immigration authorities, from employment insurance providers, the tax office, employment law supervision, and the Social Security Bank. It was then making predictions about whether people were making suspicious claims or not, and creating a risk report, which was then sent through. And this has been the subject of litigation. If you want to know more about it, please go to the website AI Law Hub, and you will see that we've blogged about this and written about it extensively. But there are many other places where people have talked about this particular system, which was litigated and has been the subject of change. And then HourView. Now, HourView is an organization which Masters and I were engaged with in litigation last year. Harview is an American company which was offering a system of online recruitment used by many very, very large companies. And we were engaged with it when a well-known company last year used it to select people for redundancy. That is to say, during the pandemic, they wanted to reduce their headcount. And because of lockdown, people being unable to come into interviews, they decided that they would use a computer-generated interview. Their workforce were invited. This is the international company that had bought this product from Harview. They invited their workforce to be interviewed by computer through their handheld phone, their mobile phone, and they used a Harview algorithm to score the way the individuals responded in this interview. And then they selected people for redundancy as a result. We were instructed by 3 women who wished to challenge the decision to make them redundant. And the organization that had bought the product from Harview then told us that the interviews, which had been done by computer, had analyzed some 11,000 data points, looking at the way they spoke, the shape of their face, the way they smiled, and 11,000 odd different points in the computerized interviews, compared them with some unknown data set to reach the conclusion that they should be made redundant. I should say that these 3 women that we acted for were in otherwise absolute model employees. And in due course in the litigation, the company settled the case. Harview subsequently have changed the way that they have operated. So there's a range of different ways in which discrimination is happening. But it's also happening in other very significant ways. The European Parliament recently published a report about the use of artificial intelligence at European Union borders. It noted biometric identification through automated fingerprint and face recognition, emotion detection, and then an algorithmic risk assessment was being used in border controls. And I myself have seen this in action. A couple of years ago, traveling back from Brussels to London, we went through the automated gate in the Eurostar terminal. And it was fascinating to watch how the AI system that determined whether you got through the gate or not repeatedly refused to allow Black people through, whereas Masters and I got through extremely quickly. Now, that was just a very simple example of it. And it didn't deter very long because the individuals were seen quite quickly by a person operating the customs tool. But it was an example of differentiation that looked highly suspicious. And we're going to see more and more of this, particularly as migration around Europe is becoming such a critical feature. It's quite interesting to look at the report from the European Union, the European Parliament in this report, saying that even where legislation prohibits basing risk indicators on criteria that involve a high risk of discrimination, these characteristics about religious belief, ethnic origin, and so on can be correlated or inferred from other types of data. And information about a traveler's various different things and preferences could be taken to reveal a traveler's religious beliefs. And moreover, excessively broad criteria used for risk assessment could lead to a significant number of false positives mean that persons are wrongly matched with a certain risk profile. Now, in the current context, I hardly need emphasize how significant that could be. And so that's another example of how discrimination can fit into the system. So what's being done? Well, discussions about discrimination, because AI systems operate in the way that they do by creating what are believed to be stereotypes that are useful in these different kinds of contexts, have led to many discussions about what we should do about it. And essentially, there are the following different approaches which have taken place. The first thing that happened was the setting up of ethical principles. People began to realize that this was an ethical problem. Secondly, data regulators began to look at this. But one of the problems about data regulation is that it's based principally on the approach taken in the GDPR. And the GDPR does not operate in relation, it doesn't have constraints on every kind of discriminatory action. It has some which are particularly high risk, but others which are ignored. And then there was the discussion about the action that should be taken by national human rights institutes and equality bodies. And we'll talk a bit more about that in a moment. But there were resource problems and technical problems about the work that they could do. And of course, this is now being confronted. And finally, we've got to the place where we are now, where we're talking about specific regulatory legislation. But I want to say just one point about this. Yesterday, we talked about this. We heard from the Council of Europe, and we heard the discussion about the AI Act. And the approach here is much more generic, not necessarily particularly specified about discriminatory impacts. And this is a bit of a problem as we go forward. Nonetheless, it's perhaps worth saying that there is quite a lot out there which gets to grips with some of these discrimination issues. So if we go back, I'll just go to the previous slide for a moment so that you can see what I'm trying to do. Let me see if I can do it. Here we go. Yeah, we've got A, B, C, D. And I'm just going to say a little bit about both of those, all four of those. So the first thing, the European Union did set out some useful ethical guidelines which did seek to address equality and non-discrimination issues. It said that it was unethical to use AI systems which failed to show equal respect for the moral worth and dignity of all human beings. It said that went beyond non-discrimination, which tolerates the drawing distinctions between dissimilar situations based on objective justifications. So it was quite a powerful statement. Went on, in an AI context, equality entails that the system's operations cannot generate unfairly biased outputs. E.g., the data used to train AI systems should be as inclusive as possible, representing different population groups. And this also requires adequate respect for potentially vulnerable persons and groups such as workers, women, persons with disabilities, ethnic minorities, children, consumers, or others at risk of exclusion. So it was a powerful statement, but it was only an ethical principle and it didn't immediately give rise to legal rights. Data regulators began to get involved in this, and last year, the European Data Protection Board and the supervisor made these comments on the proposal for the AI Act, saying that there must be a prohibition on any type of social scoring. It goes back to, for instance, the Siri case in Netherlands, that there should be a ban on any use of AI for automated recognition of human features in public accessible spaces, such as of faces, but also of adopted gait, fingerprints, DNA, voice, keystrokes, and other biometric or behavioral signals. There should be a ban on AI systems categorizing individuals from biometrics into clusters according to ethnicity, gender, as well as political or sexual orientation, and it cited Article 21 of the Charter. And there should be a ban on the use of AI to infer emotions of a natural person. So here's an example of the data regulators getting involved and saying how discrimination should be addressed. Dee Masters and I, as I told you earlier, were instructed to write this report for Equinet, and National Human Rights Institutes and equality bodies have been looking at this report and working out what they want to do. So in the UK, our Equality and Human Rights Commission has now got a work programme built around this. I know that equality bodies in other countries in the European Union, and indeed more widely across Council of Europe, are also operating in relation to this. I had a communication just 2 days ago about the way in which, for instance, the Dutch equivalent body was taking steps forward here. And one of the things that we pointed out was that there is already powerful equality law which is there to be used and must be applied. The question is how to do it. So let's just have a look at how existing laws can operate. Well, we've got existing laws across the entire European Union and within, I think, pretty much every country of the Council of Europe prohibiting direct discrimination. It would be obviously direct discrimination to classify somebody as a gorilla because they're black. It would be indirect discrimination if you have a system that, for instance, correlates some social attribute disproportionately with religious belief or ethnicity. Then the failure to make reasonable adjustments. This is, of course, concerned with disability. And one of the big problems for artificial intelligence is that it cannot deal with the very, very broad range of different kinds of disability. Harassment laws, the gorilla example again, that plainly could be highly harassing. And there are many other examples. So there are existing laws which work well to deal with these things in theory. They've got to engage with the poor training set of data, with biased inputs, with biased learning, with bad data collection systems, and critically, where there is no human interaction to moderate what an AI system does. But the problems are observability, knowing when discriminatory systems are being used, transparency, as in my example of HireView, understanding what is happening. And then there's a third problem, the rule of law, because judges are not always up to speed in the way AI systems operate. There are now beginning to be some training going for judges to deal with this. And there's a general problem about the adequacy of legal systems. Where does the burden of proof lie if you think you've suffered discrimination because of an AI system? How do you establish that? Well, there are resources on how to deal with this, and I'm just going to flag them up. They are also in the pack that you've got online, setting out some of the things that can be done. The Fundamental Rights Agency did a fantastic survey of this, Getting the Future Right on Artificial Intelligence and Fundamental Rights. I think we've got somebody here from the FRA, and I congratulate you on that work. Our Centre for Data Ethics and Innovation in the United Kingdom has produced a review into bias in algorithmic decision-making. We were on the steering group for that. There's a very, very good report from Carsten Orwat for the Federal Anti-Discrimination Agency in Germany on the risks of discrimination through the use of algorithms. It's a document I've returned to many times. Frederick Borgesius' report for the Council of Europe is there as well. And those are excellent resources for looking further into these issues. So regulatory legislation, just a quick word about that. The first thing is that we've been looking at this from Europe, but you need to know that already artificial intelligence bills or resolutions have been introduced in 17 different states in 2021 in the United States, and there'll be more this year. Of course, that brings us to what's happened here. You know about the AI Act. You know about the KHI proposal. We've heard also yesterday evening about this, I can't pronounce it properly, no longer KHI, but KI, and the intention of the Council of Europe to try and create universal legislation. But that's some way off. And there's one key question which I think we need to remember, which is that this is looking generically rather than looking at sectorial legislation. And that's important and something that perhaps we need to talk about. I'm going to go through these next slides extremely quickly so that we have time for talk. You'll see what next for the Council of Europe. These are some of the proposals coming out of the KHI report, which we discussed yesterday. And then we've also got the key elements of the EU's proposed AI Act, and these are from the recitals, where there are a number of different important statements in the recitals about what is to be expected. They cover many of the points which we have already spoken about. And the question will be whether the tour de table between the European Parliament, the Council, and the Commission will produce an AI Act which actually covers all these points in the recitals. It's going to take me too long to read all of those, but you can see, and you've got the online slides anyway, so you can see them in a PDF in the folder if you want to go back to them. So just to bring it up in a summary, the problem, a huge imbalance of power. Here we are, a group of us people. We give our data to the data companies. The AI systems have this very big data, and then they use it to affect us. But what resources do we have to redress this imbalance? The way ahead looks very difficult. What can any of us do? Well, the first thing is to understand the problem, and that's why you're here. The second is to analyze and to look at it, actually how it operates in our own countries, and then we're all called to engage with it. Understanding, our Equinet report said we need to map the territory in each country through public inquiries, domestic desktop reviews, and engaging with experts and carrying out thematic reviews. Then we need to analyze in our own countries, what are the legal gaps? How can our domestic legal system, which has got discrimination law, engage with the way AI is being used? And work out there whether there's a need for domestic legal reform as well as this national or international proposals that we've heard about. Is the principle of non-discrimination sufficiently broad in your country? Is it clear who will be liable for any discriminatory act? Is there a sufficiently developed principle of transparency? Are there sufficient procedural safeguards? How does data protection regulation work with your equality regulation? Is there adequate public guidance on the legal controls? All of those questions are developed in the report we did for Equinet, and we commend that to you. And finally, engage. Consider test or strategic litigation, collaborate further with regulators, and train the public and engineers and coders on equality issues arising from AI. Press for equality by design, and engage with data scientists and similar experts. Only then can we make AI systems work for us, free of discrimination. Build and maintain your expertise. So let's have a discussion. Any questions or thoughts?